and DSTV channel 279. We're all across the world on 3news.com. I am Alfred Ocansey. Tonight, suspended Chief Justice and Leadership Justice Gertrude Eraba Esaba Saki Tukono has taken on the committee inquiring into the petition seeking her removal, hoping to restrain it from its work until a suit she filed at the Supreme Court earlier today is determined. We have the details for you, the relief she's seeking. Stay with us. Also, the university's Senior Staff Association have declared indefinite nationwide strike over what they say is an unfulfilled agreement. What exactly is the unfulfilled agreement, and with who exactly? And what is the responsibility of this administration they are asking for? Stay with us. We've got details for you. The Ghana Cedi continues to appreciate against the United States dollar and other major currencies. But former Vice President and flag bearer of the NPP, Dr. Mahmoud Bawumia, insists that John Dramani Mahama-led NDC government cannot take credit for this. We'll hear from a financial analyst who is looking beyond the politics of the Cedi appreciation and looking at exactly what the numbers say. Stay with us. As always, you're an integral part of the conversation. Let's hear from you. The hashtag we're using is Ghana Tonight on Facebook and on X. Let's get talking. Oh, let's settle for Ghana Briefs.
Chief Justice Gertrude Tokono has filed an interlocutory injunction at the Supreme Court to stop the 5-member committee set up by the President from proceeding with investigations into 3 petitions for her removal. She also seeks to restrain Justices Gabriel Scott Puamang and Samuel Kwame Adibu Asiedu from participating in the committee's work. The Supreme Court has dismissed 2 more injunction applications seeking to restrain the work of the committee probing petitions for the removal of suspended Chief Justice Gertrude Tokono. The suit, filed by civil society group Center for Citizenship, Constitutional and Electoral Systems, and a private citizen, Kofi Atakorte, were found to be unmeritorious and accordingly dismissed.
Well, they have spoken. I will go into conclave with my lawyers and we will advise ourselves. Right.
The Parliamentary Select Committee on Tourism, Culture, Chieftaincy and Religious Affairs visited Tourism Minister Ablaji Fagomashi to strengthen collaboration and oversight. The meeting aimed to boost policy implementation and service delivery in the cultural and tourism sectors. The minister expressed readiness to work with Parliament and highlighted the recent recognition of Ghana's Kete fabric by UNESCO. Teachers across the country are raising red flags as the Pre-Tertiary Teachers Association of Ghana threatened to withdraw its services over a surge in violent attacks against educators on school campuses. The association says these incidents are taking a toll on its members and demands urgent action from the Ministry of Education. Adokwe Awule is the vice president of the association.
If the workplace is not safe and there is violence, per the Labor Law Act 651 and the ILO Convention, and we have signed to that Act 190, we have signed to it, then the best thing is to leave such an environment. If it is safe, I will go back there. Because if I cannot intimidate a student, but that student can intimidate me, and you think it is right.
Western Regional National Security Liaison Officer Brigadier General Musa Weja, retired, has indicated that logistical challenges have become a threat to the fight against illegal mining in the region. Speaking after an operation by the Western Regional Security Council to clear illegal miners along the Ankobra River in the Evaluate Jomoro-Jura constituency, he vowed to ensure the river returns to its normal state.
I want to stress that it's not going to be a one-day operation. That it's going to be sustained. we are going to do more of that and possibly try and then get canoe and sail along the Ankubia River to ensure that this river return to its normalcy.
There's more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. We're live as well on 3FM 92.7, also on TV3 Ghana on Facebook. And as always, proudly brought to you by Flamingo Paint, Simply Superior, and Sasso Insecticide Spray and Quell, Kum Tum Tum Precom. Coming up next, suspended Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Tukono has taken on the committee inquiring into the petition seeking her removal, hoping to restrain it from its work until a suit she filed at the Supreme Court is determined. Now, we have details of this latest one for you. That's what essentially this means. This is a very, very interesting development in this particular case and how things are playing out. The Chief Justice, suspended Chief Justice, is taking her destiny into her own hands, taking it up to, as it were, file this an interlocutory injunction that has been done as about 3:15 p.m. earlier today. That is the time that we have on the court documents that we have a copy of. I'm going to show you portions of it shortly. This interlocutory injunction at the Supreme Court has been filed earlier today, seeking to halt the work of the 5-member committee established by the President to inquire into the 3 petitions against her removal from office. Later, we got to know that the petitions are 5 as we speak. Well, also, the number of suits or the applications seeking to halt this process that is underway, this one adding up by the Chief Justice increases the numbers to 5. 4 of them have been dismissed. Now, in this suit filed earlier today by the suspended Chief Justice, we have a copy of it cited by us. Justice Gertrude Tokono is praying the court for a number of reliefs in order to restrain the committee from taking any action in connection with the prima facie case determined against her. We have the full details of the reliefs, quite a number of reliefs that she's seeking. We're going to go through them one after the other, but there are a few of them that we'll spend some time on because it points to something pretty interesting. And some of the reliefs she's seeking as well are contained in some reliefs sought by previous applicants. In a number of these applications, as have been determined already. Now, what does that say as well of this particular one that has been filed by the Chief Justice? Dennis Poberi Wadam Esquire is with me in the studio. We're going to run through this, and it points a very, very, very interesting picture as we're seeing right now. Dennis, good to have you. Good evening. Thank you.
Always a pleasure being here.
Always good to have you join us. And let's establish this first of all. In what capacity is the suspended Chief Justice filing this application?
Well, so from what we see on the record, she's doing this in a capacity as a citizen of Ghana.
As a citizen?
Yes, whose rights have been infringed upon multiple times, and that you would see that endorsed in the application that is before the courts, also in the writ of summons that she has also filed at the Supreme Court.
Interesting stuff. Now, but I know you're going to do a recall of all the other applications that have sought to stop the process that is underway to hear the petitions against her, and then also that process seeking her removal. How many so far?
So far, this will be the 5th one, and that's in respect of the injunction applications. But mind you, for every injunction application that has been put before the court, it means that there's a substantive suit, because injunction applications do not go alone.
Absolutely.
There always has to be a case. So we have counted 5, and this is the 5th one from Justice Gertrude Tokono herself, Her Ladyship. And this time around, she comes as the plaintiff in the substantive matter and the applicant in the matter of the injunction application. And this is yet to be heard, as you have seen. And this will be the 5th one. We've seen the 1st, 2nd, 3rd, 4th. So the 3rd and the 4th ones were heard earlier today. We'll come into that matter.
Absolutely.
But what we're having to deal with now is this injunction application by the Chief Justice. I mean, there's still not been a date when this will be heard, but it's been filed we have the injunction application, we have a copy of the writ of summons itself. So basically, this is what you see, and the relief that she's seeking, generally...
Very interesting stuff, and let's get into that.
Yes,
maybe...
but first off, let's establish who the parties are, because this presents a different dynamics to what we have seen earlier. Because in the earlier suit, you would see that it is the Attorney General, or in some instances, the Attorney General, and then the chairman of the committee, that is his Lordship, Justice Poamang. And in today's one, there was an addition of Justice Gertrude Tukono herself as a defendant. However, what we see here, it now adds all the members of the committee as respondents in the injunction application, and of course defendants in the writ of summons itself.
And that's in her ladyship Gertrude Tukono's interlocutory injunction application?
Yes.
These are the respondents?
These are the respondents.
The Attorney General.
So in addition to the Attorney General, you have Justice Gabriel Poamang, you have Justice Samuel Adibu Eseidu, you have Daniel Yaodemolevu, you have Major Flora Dalugu, and you have Professor James Sefa Jifa. These are the respondents in this injunction application.
But these are the members of the 5-member committees?
Yes, so take out the Attorney General. The rest are the members of the committee that has been put together by the President together with the Council of State to inquire into the petitions that are seeking the removal of the Chief Justice, now suspended. And that is actually the reason for which we are having to deal with this particular matter. Let's look at what exactly she wants by way of this particular injunction.
Right.
Who should be injuncted and what exactly? So, one, that she wants a restraining order directed at the committee set up by the President to inquire into the 3 petitions against the plaintiff composed. So it mentions all the respondents in there who are the committee members. From proceeding with an inquiry, taking any action in connection with the determination of a purported prima facie case made against the plaintiff. Purported prima facie case made against the plaintiff. When we begin to talk about what happened in court today, we'll put this into proper context. Just so our viewers can appreciate what's already happening.
Absolutely.
Now, there's another one, a relief.
No, but then let's go back a bit. Does the use of the word purported mean in any way that her ladyship Gertrude Tukono does not appreciate or acknowledge the fact that a prima facie case has been established against her?
It would appear so. And I say so because in court today, in one of the injunction applications which was brought by the CSO, which is Center for Constitutional, Center for Citizenship, Constitutional and Electoral Systems.
Absolutely.
In which the ladyship was the second respondent. There was an issue where her lawyer indicated that the crux of their matter was that there was no prima facie case determination made against her. And they were categorical about that.
I see, but then that would raise a number of questions.
Even though the applicants in that matter, the CSOs, the lawyer, their argument was that, yes, they acknowledged that there was a determination of a prima facie case, except that the determination was not served on her.
Yeah.
And to that extent, they said the whole process was a nullity. That was the crux of their argument.
I see.
Now, the Chief Justice lawyer, who seemed to agree with the arguments of the applicants, and that's the CSOs, say that yes, for them, they do not even acknowledge that there was a prima facie case. And it took quite some time to make that argument. But of course, there was a point where there was a measure that yes, indeed, the arguments you are making fall in line with that of the applicants. But they insist that as far as they are concerned, there was no determination of a prima facie case. And they argue strongly that for a determination to be made, certain things have to be done, including giving reasons. And to the extent that there were no reasons given to them as to how they arrived at that conclusion, and even with the petitions, which ones ended up making the prima facie case, and even with the allegations in which of them, that to that extent, they do not think a prima facie case had been established. And more so, they say they did not get a copy of it. So the question was, if we do not get a copy of it,
a copy of the prima facie case,
what exactly was she supposed to be responding to? So that was the argument that the lawyer was making then as a defendant in this case. So from that point, it already gives a clear picture of how lawyers for the Chief Justice are proceeding on this particular matter.
Which has resulted in what
so
we're
it's
saying.
not surprising to see this relief describing the prima facie case determination as purported. And Alfred, just to add, the argument was premised on the fact that they only saw a communication of the purported prima facie case determination from the presidency.
I see.
So they make reference to the letters that were issued from the presidency announcing the determination of the prima facie case. They say that cannot be the prima facie case, but that was just an announcement of a purported prima facie case determination. It was quite an interesting one in court today, Alfred.
You sat through that court hearing.
Yes, I did.
But let's flip through the next.
Yes, so the next is an order restraining the second and third respondents from presiding over. Now, second and third respondents, let's go back. Yes, so we appreciate this. Now, second and third, Justice Gabriel Palmer and Justice Samuel Adibu Esedu, these are the two that, beyond seeking to restrain the whole committee, she specifically wants these two to be restrained.
Why is that?
We'll find out later. But she makes the case that in the case of Justice Gabriel Palmer, that he had made decisions in favor of one of the petitioners, who is Daniel Ofori. And to that extent, he does not qualify to chair the committee or even be a part of the committee. In the case of Justice Samuel Edibu Esiedu, you recall that the first time the MP for Old Tafo went to court to seek an injunction in this particular matter, the original panel that was constituted, Justice Samuel Edibu Esiedu was on it.
Was on it.
It is the Chief Justice's argument that for the fact that he was part of that panel, right from the word go, to determine an injunction application against a matter that she was involved in, that also disqualifies her. But Alfred, remember that at the day that that application was dismissed, lawyer for Vincent, who is in the person of the former Attorney General, Godfrey Yabo-Adami, made that a point. The two preliminary objections that were raised were to the fact that they were against the reconstitution of the panel. One. True. And also against the chairperson of the panel. Yes. But the point to be made is that this was the reason that that objection was raised.
And that's what the Chief Justice
did not understand why
citing now.
The panel should be reconstituted.
So Godfrey Yabo-Adami was a lawyer for Vincent Assefuah in this particular case.
In that matter.
Case that was
precisely so.
Who is the lawyer for the Chief Justice in this particular interlocutory injunction?
Okay, so let's separate the matters. In this particular one, as in, okay, so this is the one that is here to be heard. It is still the former Attorney General, Godfrey Yabo-Adami. However, in the matter that I just described and referring to lawyers who were, or a lawyer who was representing her in today's matter, it was an entirely different lawyer.
Yes, but this particular one, is it Godfrey Yabo-Adami?
Yes, in this particular one, it is
for the Chief Justice.
Yes, for the Chief Justice.
Okay, let's flip to the next.
The third relief that she seeks is an order suspending the operation of the warrant for the suspension of the Chief Justice purportedly issued by the President under the Constitution. So this basically talks about the suspension warrant that has been issued for which the Chief Justice is now under suspension. Alfred, again, let me indicate that this matter came up again in court today because there were two interlocutory injunctions that the court had to decide. First was the one from the CSO and the other one from Theodore. Now, when Theodore, the lawyer for Theodore, started to move his application, the presiding judge, who is the acting Chief Justice, drew his attention to the fact that, because of course one of the reliefs was to suspend the suspension of the Chief Justice. It had to do with the same warrant thing. He drew the lawyer's attention to the fact that they had made a determination in a matter with a similar relief. But the lawyer's argument was that, yes, he acknowledges that, yes, that determination was made, but his arguments are different. So they asked him to move on. Just when he started, then Justice Amadou Tanko intervened and said that he offered an advice of some sort. That, yes, because there are full reasonings are not yet out. And that, of course, in the case of the Vincent, the day given for the full ruling to be out would have been today. So he said one would have thought that under the circumstances, since you have similar reliefs and seeking basically the same thing that the court has already ruled on, one would have thought that at least a lawyer who intends to come would actually wait to see the ruling of that particular, the reasoning of the court in those matters. And if they do not address the matter that you are coming to the court with, then you can tweak your argument or your relief and come. However, it was just an advice, leaving it to him whether he still wanted to continue or he could decide otherwise. But he still continued. And that's how come, I mean, from that point, it was a clear signal how that application was going to end. And indeed, it ended just like the one for the CSO. 4-1 majority, they dismissed it. So that's how things shaped up in court, Alfred, today. So these are the reliefs that she's seeking by way of the interlocutory injunction which has been filed.
Yes, I know you're going to go through a few more of the reliefs and one that talks about the in-camera hearing and her decision, as it were, to waive that particular relief or the right to her to have an in-camera hearing. We're getting to that. But while you flip that, let me bring in Martin Pebu, his private legal practitioner, and how all of this is playing out right now. Counsel, good evening. Thank you so much for joining us. We've heard a few of the reliefs that the suspended Chief Justice is seeking in this interlocutory injunction. And also, we're getting to know as well that for this interlocutory injunction, it is the former Attorney General, Godfrey Yeboah-Dame, who is her lawyer as well. How does all of this play out for you?
I'm totally surprised, and I'm shocked. I mean, to be very candid with you, shocked because, look, number one, I don't know why of all the lawyers this world, the Chief Justice went for Godfrey Dame. Godfrey Dame, who was caught on the Japati, being engaged in very unethical conduct, and you see that this is the person the Chief Justice is choosing, then you are like, oh, maybe, you see, I mean, the optics, it's not everything I can say, but the moment you draw that linkage, you see that, we are in trouble. Yeah, we are in extreme trouble. Then you begin to ask that, okay, so is this part of the reason why Godfrey Dame never got sanctioned in the first place? You see, so people can draw all manner of legitimate questions from this alliance. Yeah. It's very tacky. Very tacky. It's a difficult situation. Because Godfrey Dame was very unethical in the Japati. He was coaching a witness, suborning a witness, all those things. And then you find the Chief Justice go for Godfrey Dame. They're like, okay, now you would understand certain things. Look, Mr. Ocansey, this is not the last you see of this alliance. You're going to see a lot more things that will be very, unpalatable. Yes. I mean, trust me, in this nation, we sit here, you can see certain things. It's terrible. It's really terrible. Yeah, to be very honest. But look, if we don't speak the truth, we will not get far. I mean, come on. This is a guy who has an ethics case, a very serious one at that, on his head. And you say he should come and lead the charges. And he was Attorney General. You see, in the Speaker case, there were issues. You know, people had raised many questions. So this link begins to answer some of those questions. So it's really a serious matter. Yes, it's really serious. I'm shocked. I mean, to be very honest, I'm shocked. You say it. So, but, well, it's a democracy. Somebody say, well, the General Legal Counsel has not dealt with the case yet, and so we cannot draw conclusions. Yes, fair enough. Yes, the General Legal Counsel hasn't gone into it. But there are also certain situations where you always need the Caesar's wife's test. Live beyond reproach. You see, there are certain things you should do that will be said that they shouldn't draw suspicions. That's a key thing. Don't do certain things to draw suspicions, especially as you knew, as there were already suspicions when the Speaker matter came. Yes, there are suspicions. They are not, somebody will tell you that a multitude of suspicions do not constitute proof. Yes. So taking Godfrey Dame as a lawyer in this case, for me, it does a lot of damage to the Chief Justice case. It does a lot of damage, at least in the court of public opinion. And a lot of the time, public opinion is very important. The optics are very, very important. The optics even go well ahead of the substantive decision. But let's see how it goes.
Right.
You know, but in her right to also approach the court, by all means, you see that to the extent that they've gone to court, they will be able to demonstrate to you that their case is a bit different from the Kofi Korte case that was just dismissed today. So yes, that's one thing you are bound to find. Right. I mean, this is the work we do. Once you find a lawyer saying, I'll go to court, then he's trying to say that his case is different from the precedent, as I had mentioned earlier on.
Indeed, but just to make the point that no two cases are the same, no matter how similar the reliefs are, as we have referenced. But, Counsel, earlier you made the point that, in your view, the suspended Chief Justice should have resigned by now to, as it were, you know, save us all this process going all the way down to the wire. But it is well within her right, is it not, for her to go on this path of exercising that particular right of going to court, seeking this interlocutory injunction and all the reliefs in there, isn't it?
Oh, yes. It's within her right to go on. The Constitution allows that if a person is not happy, okay, with a decision, you can approach the court. You always have the right, all right? And even the Constitution itself, you see that in Article 125, they'll tell you that justice emanates from the people. Yes, right now the acting CJ is no longer, the suspended CJ is not in office as a CJ. So more or less, if we say justice emanates from the people, she'll be counted among, even when she was sitting as Chief Justice, when we say justice emanates from the people, she would also be counted, notwithstanding that she also wears another cap, or she wore another cap as CJ. So it's well within her right to go to court, okay? Yes. The only problem I have, and that's quite significant, is that because of who she was, I mean, Rana, she's suspended, you know that a case concerning her will attract a lot of public interest. And as the public scrutinizes the case, it's the long term is the judiciary that will come up short because, as I mentioned earlier on, for a lot of people, they engage in conspiracy theories and they are okay because they will tell you that you will never find the truth. So whatever your eyes see is a truth. Don't mind that somebody can come later and prove something otherwise. So with these accusations, counter accusations, the judiciary is losing face. The judiciary is losing, apparently, even if not real, there is a loss of confidence because it will be like, oh, so the judges can't deal with their own matters. Do we have to wash? Do they have to wash their dirty linen in public, etc.? There are so many things that will go against the judiciary and also against, when we say judiciary and by extension, the legal system. And so lawyers, we are also affected because lay people will reach out to us that, hey, you guys, what's happening to you? Because they count us together with the judges, etc. Right? So there'll be some kind of loss of confidence, even though the other side too is that the more citizens question the justice system and express their opinions, we are likely to get reforms. We are likely to find the justice system more responsive. But as I said, for me, for now, it appears that the damage is more because where we need citizens to weigh in and to contribute more is about reforming the justice system, getting a modern justice system. Our justice system is outdated. Okay, it's not modern enough, right? In terms of the trial, procedures, right? The substantive law, there are a lot of things that have changed. Okay, we used to copy a lot from the English people. Yeah. Now there is a wide gap between us and them. We are not catching up. So those are the weightier issues, right, that we expect that if citizens should weigh in, that's the direction we need more help, rather than matters of disciplinary issues concerning judges. So that's how come I would have wished that the Chief Justice would go by the biblical edict in saying that everything is permissible for me, but not everything is beneficial. Yes, Mr. Ocansey. In 1 Corinthians 6-12, the Bible says that everything is permissible for me, but not everything is beneficial. So in this case, yes, the Chief Justice has a right to go to court. But if you look at what the whole justice system is suffering, the unnecessary scrutiny at this time, you see, I mean, it would have been better that the Chief Justice resigned so that the system can, quickly try to heal and then, we make progress.
Well, but you also acknowledge as well in that earlier position that, yes, it is within a right to want to go the long haul down to the wire to see how this process would end full scale. But then, Counsel, stay with me, and then we'll also hear from Kwanzaa Sari, former director of the Ghana School of Law, in a bit, because apart from the two reliefs that Dennis highlighted earlier, there are a few more reliefs that the Her Ladyship Justice Gertrude Esaba Tukono is asking in this interlocutory injunction. Dennis, what do we know?
Well, so the three reliefs that I just did a while ago, those relate to the interlocutory injunction. Now, what we are about seeing are reliefs that are being sought in the substantive matter. So these that you would see, which involve some of the things that we may be hearing for the first time, because there haven't been things of public record, are indicated in this, which is in the substantive matter. So the first relief, she basically wants a declaration to the extent that she has a right to a public hearing. So she cites the provisions of the Constitution that relate to everybody being equal before the law, the right to fair trial, and also the provisions that relate to the constitution of the committee and its work, commission of inquiry, and then the exercise of discretionary powers. Then there's a part where she now says that she wants a declaration that the Chief Justice can waive the in-camera nature of the proceedings under Article 146. Mind you, we have said on this show, time without number, that the whole proceeding is supposed to be in-camera.
Absolutely.
But she is saying that she wants a declaration that the Chief Justice has the right to waive that particular right that she has. I mean, or the nature of the proceedings.
Let's see.
Is that to suggest that there's been a request for such to be waived? We don't know.
Well,
we're only seeing this.
Because we had read some media reports that
yes,
she had
that seemed to suggest.
Requested that, this in-camera one be put away. She wanted it telecast for us all to see the hearings of this 5-member committee. From the communication last week...
But that is supposed to be in camera.
Absolutely. From the communication last week,
yes,
this 5-member committee's hearings have begun.
Precisely so. And they are ongoing.
And they're ongoing. And this, she's asking that she wants that right that she has as an accused person in this particular case.
She wants a declaration to be made that that right can be waived.
So then we would all see.
Yes.
The committee is here.
That it can be waived so that she has the option to waive or not to waive. Or anyone, not just her, but that anyone who is in that situation would have the option to waive or to stick to what the Constitution provides. And that she wants a declaration in that regard.
I see. But then what does the 1466 state in dictate? The specific detail of it there. Does it give in this case, the suspended Chief Justice that leeway or the right to ask that this particular in-camera hearing within her right be waived? Mind
you, she came from a number of provisions. So when you look at all these provisions and what they provide for. 17.1. 17.1, equality before the law. 19, the whole of 19 is on fair trial. 1, 4, 6, 7, and 8. These are the matters we're talking about, the committee and its work. 281, commission of inquiry and how they should conduct their business and how the proceedings should go. 295 and all. So when you look at it, now she comes to a point where she says that make a declaration that after all these things, it should be possible that somebody who comes to these proceedings even though the requirement is that it should be in camera, you should have the right to waive that. That is a matter entirely for the Supreme Court to make a determination on. Whether they agree or do not agree is a different matter altogether. And these are matters that will be determined in the substantive suit.
Well, let's stay on this. And what's your own position on this? What's your reading of this particular relief that the Chief Justice, that's her ladyship, Gertrude Sabatukono, is asking in this particular one that Dennis just referenced about the in-camera hearing, and she asking that be waived in her right?
Yeah, you know, lots of people have asked that, yes, the proceedings be undertaken or done in public. Yes, I agree. I agree, because it helps. Justice is not a cloistered virtue. We don't do justice generally in secret, except in very grave circumstances, right? When there are extreme national security concerns. Please, extreme, not just any small thing that you waive national security. No. This one, I don't see what's the secrecy that it should bring. We should have it in public. So the rights, if you look at it, yes, we can't totally say that it's her right. Part of it, because it's constitutional, we need to exercise some introspection and also look at the provision well. So we are looking at Article 146, Clause, I think, 8. If I can get my Constitution. Yes, it says that all proceedings, it's either 8 or 9. That's Article 146. Okay, subclause 8 or 9. So all proceedings, yeah, should be held in camera. So the way it's been done, it's not totally stated as a right belonging to the Chief Justice. It goes beyond the Chief Justice. It's that's the person who is facing the accusations. It's also for the system. So the point I'm making is that her waiving her right to an in-camera hearing does not automatically mean that the committee is bound to grant a public hearing. No. That provision also covers the society as a whole, the governance architecture. So we would implore the 5-member committee to look at it and move. You can see that citizens have moved ahead of the Constitution and want to see it play out. So that one is an appeal. So the argument we must be very clear about is that the fact that the Chief Justice is waiving her right to an in-camera hearing doesn't mean automatically that the committee would accede to it. The holding of the proceedings in camera, that's in secret, all right, is not meant to protect only the person answering the accusations. That is to say, in this case, the Chief Justice, but it's also for the system as a collective. So it's for the committee to look at it. Maybe they may even say that, okay, then they want the Supreme Court to deal with that matter, that aspect of it, and then they can be guided. But it doesn't mean also that the 5-member committee must stop the hearing. We've already addressed the question of an injunction. The injunctions are not granted in such cases lightly. So the proceedings can continue, and if it turns out that the Supreme Court is willing to give an answer on the in-camera hearing quickly, when it is done, then we'll catch up with them. That is to say, the proceedings will then be telecast live from the date the Supreme Court accedes to such a request. That's if only the Supreme Court agrees that, look, they can interpret it to say that the proceedings should be done in public. But Mr. Ocansey, once again, I must say that that's a tall order. If, to be frank, it looks to me easier that we will make it a public hearing in the next Constitution than to do an interpretation of this current one to say that it means you can also do it public. This current Constitution is much more difficult to interpret to get such a conclusion.
Right. Counsel, appreciate your thoughts on this, and I thank you so much for your thoughts, as always, joining us here on Ghana Tonight. Martin Peoples, private legal practitioner. There are a few more reliefs that we'll want to run through before we draw out the curtain on this latest development, and this time around, the Gertrude Sabatukono herself taking matters into her own hands in the capacity of private citizen going to court, asking the Supreme Court for an interlocutory injunction on the entire process to have her removed as Chief Justice. What more do we know?
Well, so this one is at the heart of the whole thing that we are talking about now, where she's asking for a relief to a declaration to the effect that the prima facie case, as we are told has been established, has not been properly done. Yes. So this is just a summarized version of it, but the longer version of it is to the fact that the purported prima facie case, as was served on the plaintiff, that's the suspended Chief Justice, on this day, was not determined the way it ought to be determined.
Right.
And what that simply means is that if this is upheld, it effectively means that everything that flows from that will be a nullity. But of course, she says that to the extent that in her view was not properly done, all the processes that followed, i.e. the constitution of the committee, the referral of the petition to the committee to look at it, her suspension, and all the ongoing processes should be declared null and void. So all the subsequent reliefs, in one way or the other, are also in furtherance to that particular relief that she's seeking, that a declaration be made that the prima facie case has not been properly done. And that to the extent that it wasn't properly done, it was done arbitrary, it was capricious, and it was in violation of fair trial rights. And to that extent, it should be declared as unconstitutional. She also says that by that very act, this is also seen to be an infringement on the independence of the judiciary. She also wants a declaration in that regard. Procedurally, she also wants some reliefs, and that's to say that a declaration that the committee was constituted without the plaintiff properly served the purported prima facie determination. And that was actually one of the key things that the applicants today who were seeking an injunction, that was where they mounted their case on, that the Chief Justice has not been served a copy of the determination of the prima facie case. And to that extent, they wanted that the injunction granted. Unfortunately, things did not go their way. The reason of the court is here to be out somewhere May 29. There's also a relief that she's seeking for an order to set aside the president's suspension warrant. This we have dealt with it already because it had come up in previous proceedings before the court. But yes, it's a relief she's also seeking. Now, this is where she takes it now to some specific members of the team. Disqualification of Justice Palmer, she wants a relief in that regard.
I see.
And that is she makes the point that Justice Palmer, as chair, he had made some rulings that went in favor of one of the petitioners, Daniel Ofori, and to that extent, a declaration should be made that he does not qualify to be the chair or even be a part of the committee. Then again, he says that if he's disqualified, he should be prohibited from being part of the committee. Then he takes it against Justice Adibu Esedu, essentially making the argument that he was part of an interlocutory injunction that was seeking to hold the process at its beginning, and to that extent, it's a violation of judicial independence. So he too should not be part of the committee. He should be prohibited. He should be disqualified. So you see all of those in the alphabet. They go on up to 15 of them.
15 reliefs.
Yes, so there's also another interesting one which seeks to disqualify the other 3 members. And she makes reference to the Oath Act and to say that these committee members do not qualify under the Constitution to perform the functions that are supposed to function under the committee. So essentially, this is what we are having to deal with. This is a substantive matter. The interlocutory injunction likely will be heard before the substantive matter. And we may be back to court for the 5th interlocutory injunction while the process is still ongoing.
Interesting stuff. And it's very important that you put the matters in perspective, making reference to exactly what the position of the law is, the reliefs being sought, and what happened in court today. Dennis Poberi-Wadamesko, I appreciate you as always. Thank you for coming through. This is Ghana Tonight. After this quick break, the Ghana Cedi continues to appreciate against the dollar and other major currencies. But the former Vice President and flag bearer of the MPP, Dr. Mahmoud Bawumia, insists the John Dramani Mahama-led NDC government cannot take credit for this in its entirety. We'll hear from a financial expert lifting this particular issue beyond the politics. Stay with us. We'll be back shortly. For joining us here on Ghana Tonight. And there's more of this on 3news.com. Make some time and visit 3news.com and join us tomorrow for yet another conversation. On behalf of the rest of the team, we do appreciate your company. There was a little hitch as well on Facebook, on our live stream. We do apologize for that. But thank you so much for staying with us here on Ghana Tonight. My name is Alfred Ocansey. Have a good night.
Ghana Tonight is brought to you by
Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and coil.
La